The first appeal on this afternoon's calendar is the people of the state of New York versus Levan Easley. Counsel?
Good afternoon, Your Honours. David Fitzmaurice on behalf of Mr. Easley, and I'd like to reserve 2 minutes for rebuttal.
You may, sir.
Your Honours, we're here again talking about FST, which is the black box technology that the OCME was using when faced with mixed DNA samples. As this court has held 3 times already, this technology cannot be admitted without a FRI hearing. This case is really a straightforward example of the most recent time this court considered the issue, which was Wortham. Just like Wortham, a request for a FRI hearing was denied on the merits on the grounds that it was, quote, not new or exciting DNA, and it was just math. And as a result, FST's likelihood ratio, the 4.5 million likelihood ratio, was admitted into evidence and became really the focal point of the people's case because it was the only evidence connecting Mr. Easley to the gun. So in virtually every respect, this case is like Wortham. The only real difference with Wortham is that we request the traditional remedy of a new trial, and that is because of the second issue presented by this case, which is the disclosure failures. So, the disclosure failures, I suppose, the essence of the argument is really the price of using innovative software in a criminal case is disclosure to the defense. Disclosure, put simply, is the cost of use. And here, there was no disclosure to the defense because an entire jury trial happened without a single flaw of FST coming to their attention. And again, this is FST, this is technology so flawed that the OCME abandoned using it several years ago. Defense request for disclosure was denied, and instead the trial consisted of the FST likelihood ratio itself coming into evidence, as well as an analyst from the OCME who essentially parroted this black box figure of a 4.5 million likelihood ratio.
So you didn't actually, you didn't actually request specifically the source code until trial was underway. If the court had granted your motion then, what could you have done with that?
So
the source code is pretty difficult to work through, no?
It absolutely is. I mean, it could require require an expert probably to read, though it is written. Lawyers probably can't read it on their own. But to go to Your Honour's point, the reason that this was requested mid-trial was because that's when these issues came to a head. This was black box software that wasn't disclosed in the course of the regular discovery period. I mean, I think that, and our brief...
But counsel, you did have the report in the regular discovery period, right?
We eventually got the FST likelihood ratio, but I think,
But that was before trial, or no?
It was before trial, but I think the kind of the issues with that report really came to a head after it started becoming aware that this wasn't like other DNA evidence.
Was that as a result of the Daily News article?
As a result of the Daily News article, maybe that's what alerted counsel to it, but at the time, this was an ongoing issue across trial courts in the state. And I think the point is...
So are you saying that counsel wasn't properly educated with respect to the science?
I don't think counsel could have been properly educated because there was not proper disclosure. I mean, remember, when we think about DNA evidence, before FST came on the scene, all that the OCME would have been able to do was say that it's more likely than not that that defendant cannot be excluded as a possible contributor. And now all of a sudden we're faced with this value, this 4.5 million figure. So the disclosure that typically accompanies regular DNA cases simply cannot be the disclosure that's sufficient here, because here, by the OCME's recognition, something happened that wasn't regular DNA. A computer came along and did something that the humans had been unable to do prior to then, and it only became evident during the trial because it was shielded.
And the code that's created, it's created by humans, correct?
So the code is created by humans. What defense counsel eventually, after a 5 days of discussing this issue, once he alerted the court to it, they 5-day period back and forth discussing what they knew, what they didn't know, and he requested the code, he requested the underlying assumptions, he requested the validation studies. So as part of the code,
Did it clearly request the validation studies?
I think he did, in that he asked for all materials that went to the all assumptions that were made, all written materials, and then he basically said he wanted to contest the computer.
And did the court rule as to those studies?
The court did rule, actually, and I think this is a really important point. As this was emerging, the court indulged defense counsel, had a 5-day discussion, discussion spanning 5 days. There was a weekend in there. And initially the court said, yes, you do get all this discovery, you do get this disclosure, and it instructed the prosecutor to go back to the OCME and to provide this material to defense counsel. And then what happened is very interesting. What happened after that was the court second-guessed itself, and it said, you know what, you don't get this discovery because really FST is no more than getting discovery into a chemical compound. So what the court essentially did was the court said, you know what, I think FST is reliable enough, as reliable as a chemical compound, to not require discovery. And that is exactly the problem here. It is defense counsel's role to test reliability. It can only be tested by defense counsel. That is Hemphill, that is Crawford. It is defense counsel's sole job to do this through the crucible of cross-examination. And that didn't happen here because of a reliability determination that this was just regular science. We know this wasn't regular science. This was not an abacus. They didn't generate this figure, humans didn't generate this figure, a computer generated this figure, and they did it in a black box. So what this all boils down to is a conviction based on black box evidence that was never opened up.
Thank you, counsel.
I just have one question.
Oh,
if I could.
excuse me,
Sorry.
Judge Wilson has one question.
If you could just isolate the Fry error for a moment, assume that that's the only error. I know you've alleged other things, but just focus on that for a second. Could you then address harmlessness?
Well, so with the Fry, yes. I think, again, like I said, this is very like Wortham in virtually every respect, including the harmlessness. This was the only evidence that related specifically to possession. And this court has described DNA evidence as having an aura of invincibility. And what FST did was it took that aura and it assigned it a 4.5 million figure. So without the DNA, I've already said that you couldn't make that calculation. And when you think of what evidence that wasn't DNA existed in this case, it basically consisted of a video where nobody, a video in which appellant can be seen being brutally beaten. His hands are certainly not visible. There's no gun visible. All you see is appellant pinned up against a shelf being assaulted. So when you compare this to the harmlessness that this court found in Williams, where there was eyewitness testimony and there was a confession to a girlfriend and the gun was hidden in a wall cavity, I mean, it couldn't be further from that situation here. Here there was no witness, not a single witness testified as to possession. The video absolutely did not show any gun, did not show Mr. Easley's hands at all. The only hands it showed were the hands of his assailants as they were brutally beating him.
Thank you,
Your Honors.
counsel. Counsel?
William Brannigan for the Office of District Attorney Katz. Good afternoon, Your Honors. May it please the court.
Counsel, I'm sorry, could you start with the last point on the harmless error analysis?
Yes, Your Honor. Starting from the harmless error, Your Honor, the video in this case shows the defendant reach in between a series of boxes of baked goods in the deli. That's exactly where the officer then, a few minutes later, recovers the gun from. During the entire course of that videotape, you won't see anyone else.
But in that videotape, there are other people in the store. There's chaos going on at times. No one sees a gun in his hand, correct?
I cannot see a gun in his hand in the video, no, Your Honor.
And does anyone testify that they saw a gun in his hand?
No, Your Honor. But, Your Honor, if you look at that group of people who come into the store, and it's at that point you have a 911 tape where you can hear, give me the hammer, and certain other things on the tape. Nobody else goes into that point in the boxes. Nobody else could have put the gun there, and that's why the error is harmless in this case.
And you do see the officer recover the gun on the video, don't you?
Yes, Your Honor.
And is the camera on that area for the entire 2 minutes before, from when you see some activity with his hand going into that area to then when the police officer recovers the gun?
Yes, Your Honor.
Is the camera on?
The camera's on the whole time. It also captures the people coming into the store and everything that precedes the recovery of the gun, Your Honor. But, Your Honors, the court need not reach the harmless error because the issue below was not preserved. The defendant made his FRI application in the middle of trial, well past the point when the court could have resolved the
Is there
issue.
a requirement in the CPL with respect to when that motion had to have been made?
No, Your Honor. FRI is not among the so-called pretrial motions or in the CPL. At the same
And the
time,
judge ruled on the substance of the motion. As I read that transcript, the judge didn't make a timeliness determination.
Your Honor, the court did make a timeliness determination. When he first made his application, the court said, these applications are to be made pre-trial. She also says, this is not the kind of application you make mid-trial. And the
But then
defendant,
she didn't rule. She waited, right? And then she ruled on the merits of the application.
Your Honor, but that is a holding, and she didn't pull back from that. I'd also say, if the court wasn't looking at this in terms of preservation, the question here for this court is whether the trial court abused its discretion. So first, the court said this application has to be made pre-trial. Second, the defendant then came back and said, well, I couldn't make it pre-trial. The papers were given to me too late. The court then went through with the prosecutor and discussed when things had been given. The entire package was given April 1st. The trial began May 7th. The defense attorney then said, well, I just got this newspaper article. And the court said, these types of applications are not to be made on newspaper articles.
What is the problem, is there a policy reason why you can't have the FRI hearing after the trial is concluded?
Your Honor, sorry, Your Honor, a FRI hearing basically takes months at a minimum. It requires expert testimony from both sides. So as far as having a jury around while this type of hearings going on in a criminal court is just impossible.
Well, that's a different question, really. I mean, what we've done in Wortham is effectively that, right? We've taken the jury verdict conditional upon a FRI hearing to occur, in that case, probably several years later. And it'll take however long it takes.
Your Honor, I would say it's the same thing for, say, a suppression hearing, this type of pretrial hearing.
Those are specifically limited in the CPL.
That's correct. There is not that specific limitation, Your Honor, but we do have practice, we do have custom. And the fact is that in order to decide whether this evidence is going to go before this particular jury, this issue had to be decided beforehand. Your Honor, as far as the second issue, the second issue is also unpreserved. The defendant had his discovery package beforehand. No request was made for the materials until the middle of trial. And again, if we look at the old statute 240-21C, this was not a test made for this particular trial. The tests in question here are tests that underlie the computations used to produce this, but it wasn't made for trial. It was not done at the behest of law enforcement. OCME is not a law enforcement organization, so it did not fall under the prior discovery statute, Your Honors.
Thank you, counsel.
Thank you, Your Honors.
Counsel, your rebuttal?
Very briefly, Your Honors. Counsel mentioned that the video shows Mr. Easley reaching in. The video shows Mr. Easley being brutally assaulted by 6 people and stumbling afterwards. Nobody else touched that area. The video shows nobody touching that area. And yet, Mr. Easley was not the main contributor of the DNA on the gun. We know that. That's why they had to do FST. He wasn't the main contributor. So in terms of what the gun had, it didn't have his fingerprints, it didn't have his blood, despite the fact that he's been stabbed multiple times. It just didn't have enough. It didn't have any connection except FST. Regarding timeliness, the judge certainly, puffed and puffed about the timeliness at the beginning. That's not a holding. If that's a holding, are the next 5 days just dictum? It's not a holding under any stretch. What happened afterwards was a exchange of cases, an exchange of arguments, and actually the only holding that happened here was that on the merits, it's being denied, citing Garcia because it is not a new and exciting DNA test. Garcia, the reliance on Garcia is what this court said in Williams to be an abuse of discretion. I'll also just note that in Williams, that was a mid-trial application. So the whole problem here is we're in the situation because we're dealing with a black box that was kept from the world. Convictions were based on black box technology. And I think it's also telling in terms of there not being, counsel cites to a custom that these are written, that they're written. A custom is not law. That's what Justice Kagan would call a law-free zone. There is no requirement in the CPL that they be written. There's no requirement stopping it from being mid-trial. And for that reason, the preservation arguments, which were just raised for the first time before this court, are completely meritless.
Thank you, counsel.